We're going to leave that video now because we want to take you live to Michigan, where Ethan Crumbley is appearing in court for his formal arraignment. He is the accused school shooter. Let's watch live as he is formally arraigned on the charges. He's accused of murdering 4 people, injuring 7 others. Let's go in together and watch.
Good afternoon to all. Counsel, good afternoon, Mr. Crumbley. Mr. Crumbley, can you hear me, sir?
Yes, sir.
You understand that you have a right to be present in court today. Are you okay with proceeding via Zoom just for the purposes of this arraignment?
Yes.
Thank you. Prior to calling this case, the court did have a brief breakout room with the attorneys. I did discuss the issue of any potential conflict. As all attorneys on the call are aware, I was a former assistant prosecuting attorney at the Oakland County Prosecutor's Office. Upon talking to counsel, I do not believe there's going to be any conflict with me presiding over this case. Is that correct, Ms. Lofton?
That is correct.
Okay. Any objection from any attorney on the case of me presiding over it?
Not from the people, Judge.
No, Your Honor.
Thank you. And with that being said, the court is comfortable with proceeding in this matter, and I don't believe there to be a conflict in this case. Today's date and time set for an arraignment. Ms. Lofton?
Yes, Your Honor. I would waive the formal reading, stand my client mute, ask that a not guilty plea be entered. Thank
you. The court will accept jurisdiction, enter a not guilty plea on behalf of your client. It's my understanding that according to the Juvenile Justice and Delinquency Prevention Act, that a hearing must be held before January 21st of 2022 regarding the placement of the defendant. However, because of the pandemic, we cannot effectuate an in-person hearing, which I believe it would be appropriate in this case because of the high number of COVID cases, a positivity rate in Oakland County. Because the number of COVID cases are so high at this time, the court is finding good cause to extend those 30 days because we cannot effectuate an in-person hearing at this time due to the positivity rates. It's my understanding that defense is requesting in person, and I believe that is absolutely appropriate in this matter. And so what I am going to require the attorneys to do is to submit briefs on this issue. Briefs are to be submitted on the issue of placement on or before January 19th, 2022 by 2 p.m. And we will also have a status conference on January 19th, 2022 at 2 p.m. And that status conference is only with the attorneys. And the purpose of that status conference is just to set a new date for the hearing under the Juvenile Justice and Delinquency Prevention Act. And I will note, because of the high number of victims in this case, that this recording will be posted for 24 hours after today's date. The last issue I believe that we need to address is the issue of appointing LGAL. I did have an opportunity to speak to counsel. This court is reappointing Ms. Deborah McKelvey as LGAL for Mr. Crumbley throughout this matter. Is there anything else from either party?
Yes, Judge, thank you. I just wanted to make sure that Ms. Lofton did acknowledge receipt of the general information.
Yes, I have the general information.
Thank you.
Thank you. Anything else from either party?
Not from the people. Thank you, Judge.
Nothing from defense, Your Honor.
Okay.
No, Your Honor. Thank you.
Thank you very much. I will see you all on January 19th at 2 p.m. And again, that's only the attorneys. Mr. Crumbley, you will not be present for that hearing. We're just setting that so we can set a new date. If there's nothing else, everyone is all set. Everyone have a great day.
Thank you very much, Your Honor. Thank you.
Okay, we told you earlier that would be pretty quick. So here's what we learned from this hearing. We learned that the judge has formerly been a prosecutor in the same county. So that is why the judge was absolutely right to disclose that, because if there is a potential conflict, the best way to decide whether or not it can be overcome is to disclose it before the court. So just because the judge was in that office doesn't mean that somehow he would be unable to be fair and impartial in the hearing of this case. And you saw that he asked both sides if they had any objection. No objection from either side. So we saw that judge will continue being the presiding judge in this case. And Ethan Crumbley still has a right to a jury trial as well. It's his choice whether he wants to be tried by a jury or in front of the judge. Also, we saw his attorney waive the formal reading, so the judge could go through every single charge, penalties attached. That is common, what we just saw. A lot of times, the attorneys will go over all of that with their client in private. There was no need to put it on the record from their point of view. So the attorney put it on the record that Ethan Crumbley is pleading not guilty, which we expected. That's how these cases move forward. All of the live trials we're covering, there was a plea of not guilty. That is how it gets to the point of trial. If it changes, of course, you'll hear it here. You heard the judge. I suspected the defense would be raising an issue about his placement, because remember the first time he was in court, the attorney got up and said, Judge, he's being housed in this facility where there were adults. He's a juvenile. This is a problem. He should be going to school, all of that. And so here, according to the law for juveniles, there is a hearing date that he's entitled to on that issue where he's going to be held in the time being. And so the judge extended that time for 30 days on good cause, the reason being COVID-19 and the spike in cases he noted in Oakland County, Michigan, where this case is being heard. So briefs are due by January the 19th, and that also will be the day where there will be a status conference on the matter, meaning the lawyers get together, talk with the judge, and set a new date to have that in-person hearing about Ethan Crumbley and whether he should be in an adult jail being held or in a juvenile facility. You heard the court also talking about the appointment of an LGAL. What do those letters mean, you ask? A lawyer guardian ad litem. So remember, he's a juvenile, even though he's being charged as an adult. That is totally common that one would be appointed to look out for a minor's best interest when they find themselves in the system. So here we go here on this case moving forward. Ethan Crumbley pleading not guilty. The case is in big court now. It's out of the magistrate court. He decided not to have that probable cause hearing, and now it's moving on. So we'll let you know what happens on that status conference on the 19th. I believe we're going to bring in our guest on the program to chat a little bit more about this case. We have with us criminal defense attorney and former prosecutor Marcia Minot standing by in Atlanta, Georgia. Marcia's been watching this one from the outset. Marcia, this was quick as we thought it would be. Did anything jump out to you as unusual, or is this pretty much what you expected for Ethan Crumbley today?
This is definitely par for the course. Whenever you have an arraignment, it's a person saying that they're either guilty or not guilty. You enter your plea. You ask the court respectfully for a number of days to file your motions. There are certain preliminary motions that you will file in the case. And in this situation, what the judge is scheduling is a motion hearing on the actual motion filed by the defendants regarding their belief that this defendant being housed at the adult facility where he is a violation of the Juvenile Act. So it's not uncommon. Arraignments are usually pretty quick. You go in, you enter your not guilty plea, and you ask for time to file any preliminary motions. In this situation, one had already been filed, and that's what they're going to hear on the 19th.
Marcia Minot, thank you so much for that. So much more to come with this case, and the parents also being criminally charged. It's really something, and something that is unusual to see them being brought into court on this one. Let me ask you, if I may, please, Marcia, the charges are involuntary manslaughter for the mother and father, James and Jennifer Crumbley. This prosecutor saying that they knew this was going to happen. They had so many indications. They provided him with the gun. They didn't do enough to stop this when they had those warning signs, both at the school and in their home. How do you see the prosecution of the parents going, please, Marcia?
Well, the sad part for the parents is that an involuntary manslaughter does not require that the state prove that they intended to have their son go to the school. It just needs to prove, the state just needs to prove that the parents' conduct was reckless. Reckless in buying their son a firearm, reckless because they knew their son was having mental health issues, that their son was exemplifying a lot of issues that they should have known as parents to handle before this incident got to where it did.
Marcia Minot, always great to have you weighing in. Thank you kindly.